There are breaking news developments from the Court of the Chief Justice of India, a three-judge bench looking at all of the allegations raised in the Hindenburg matter pertaining to the Adani Group. The final judgment is now being pronounced. There are important aspects of this which I'm going to go through. The Chief Justice of India, in reading the order, has endorsed the role of the Securities and Exchange Board of India, SEBI. The Chief Justice has said that the power of the Supreme Court to enter the regulatory framework of SEBI is limited. Therefore, whatever SEBI, which is probing all of the allegations, says is something which needs to be relied on. There are no valid grounds, the Supreme Court has said, raised to direct SEBI to revoke its amendments on the FBI and LODR regulations. The regulations do not suffer from any infirmity. Bring you details of what exactly that is all about. The Chief Justice mentioned that as far as SEBI is concerned, 20 out of 22 matters have already been looked at. 22 matters which had been raised in the Hindenburg case, 22 matters which needed to go through. There are 2 items which are still being looked into, and taking into account the assurance given by the Solicitor General of India. The Supreme Court has directed SEBI to complete the investigation in the other 2 items within a period of 3 months. The Supreme Court has held that there is no ground, and this is absolutely critical, to transfer the investigation to a special investigating team. So once again, reposing faith in the Securities and Exchange Board of India, making it absolutely clear that you do not need to go to an SIT, which would be an additional layer looking at all of these allegations. Over a period of time, there were allegations raised by the group, the OCCRP, and these followed the initial set of allegations which had been raised in the Hindenburg report on the role of the Adani Group. The Supreme Court has said that the report of the OCCRP, the subsequent report, cannot be taken into account to doubt the SEBI investigation. Once again, this is a repeat theme as far as the Supreme Court is concerned and this order is concerned. The role of SEBI, the process of its investigation and its credibility cannot be questioned. That's the key point. The reliance on the OCCRP report is rejected, and a reliance on a third-party organization report without any verification cannot be relied upon as proof, is what the Supreme Court, the Chief Justice, has said in reading out the order. There is no ground to transfer the probe in this case from SEBI. I've mentioned that already. The Supreme Court therefore has rejected the arguments of petitioners regarding any conflict of interest, because this had been raised by one of the judges, by one of the lawyers, I believe Prashant Bhushan earlier on. Supreme Court rejecting that argument of the petitioners regarding a conflict of interest on the part of the members of the expert committee. What exactly was the expert committee? The expert committee, when these allegations was made, was formed by the Supreme Court of India with the names of some of the most prominent experts that the Supreme Court believed could actually give observations on the seriousness or the nature of the allegations which were made. And one of the petitioners in the case argued that there was a conflict of interest in the case of some members of that special committee formed by the Supreme Court. The Supreme Court today, in reading out its order on the Hindenburg case, has rejected those arguments of petitioners regarding any conflict of interest on part of members of the expert committee. In other words, backing the SEBI in its investigation, endorsing the role and the credibility of members of the expert committee. The Chief Justice also saying that the Government of India and SEBI shall take into consideration the recommendations of the committee. This is that same expert committee that I referred to strengthen the interest of Indian investors.